Hello and welcome to Growth Mind Company, the channel where we empower you with strategies, insights, and tools to elevate your personal and professional growth. Whether you're looking to enhance your skills, boost your productivity, or simply gain a fresh perspective on personal development, you're in the right place. Don't forget to hit that subscribe button, and let's embark on this journey of growth together.
Purpose. Clause 16.2 Termination by Contractor serves as a protective mechanism for contractors, allowing them to exit the contract under specific circumstances without breaching its terms. This clause ensures that the contractor's interests are safeguarded against potential risks and uncertainties. Implications. If invoked, this clause can lead to the cessation of the project, potential financial implications for both parties, and possible legal disputes. It underscores the importance of both parties adhering to their contractual obligations to avoid such drastic measures. Primary aspects. The clause outlines 7 distinct scenarios under which the contractor can terminate the contract. These range from payment delays and non-compliance with financial arrangements to prolonged suspension of work and the employer's insolvency. Clause 16.2 Termination by Contractor provides the contractor with the right to terminate the contract under specific circumstances. This clause is essential as it outlines the conditions under which the contractor can exit the contract without breaching its terms. Let's delve deeper into each of the conditions. Subclause 16.1 Contractor's entitlement to suspend work. If the contractor has given notice under this clause due to the employer's failure to comply with subclause 2.4 employer's financial arrangements, and does not receive reasonable evidence within 42 days, the contractor can terminate the contract. This ensures that the contractor is not bound to continue work if there are doubts about the employer's financial capability. Example: in the United States, if a contractor is working on a federally funded project, and the government fails to provide evidence of continued funding or financial arrangements, the contractor might use this clause to terminate the contract. If the engineer fails to issue the relevant payment certificate within 56 days after receiving a statement and supporting documents, the contractor can terminate. This emphasizes the importance of timely payments and certifications. If the contractor does not receive the amount due under an interim payment certificate within 42 days after the time stated in subclause 14.7, payment termination is an option. This clause ensures that the contractor is paid on time for the work done. If the employer substantially fails to perform his obligations under the contract, the contractor has the right to terminate. This is a broad provision that can cover various failures on the employer's part. Subclause 1.6 Contract Agreement and Subclause 1.7 Assignment. If the employer fails to comply with these clauses, the contractor can terminate the contract. These clauses relate to the formalization of the contract and the assignment of rights and obligations. Subclause 8.11 Prolonged Suspension. If a prolonged suspension affects the entire works for more than 84 days, the contractor can treat this as an omission of the affected part of the works. If the suspension affects the whole of the works, the contractor can terminate the contract. Example: in the U.S., if a building project is halted due to environmental concerns and the necessary environmental impact assessments, as mandated by the National Environmental Policy Act, NEPA, are not completed within the stipulated time, a contractor might invoke this clause. If the employer becomes bankrupt, insolvent, or faces similar financial difficulties, the contractor can immediately terminate the contract. This protects the contractor from potential financial losses. In any of these situations, the contractor can terminate the contract by giving a 14 days notice to the employer. However, in cases related to prolonged suspension or the employer's financial difficulties, the contractor can terminate the contract immediately. Main points to keep in mind when employing Clause 16.2. Documentation. Always maintain thorough documentation of all events, communications, and actions related to the contract. This will be crucial if Clause 16.2 needs to be invoked. Timelines. Be vigilant about the timelines specified in the clause, such as the 42-day period for receiving payments or evidence of financial arrangements. Legal counsel. Before invoking Clause 16.2, it's advisable to consult with legal counsel to ensure that the contractor's decision is well-founded and legally sound. Communication. Maintain open communication with the employer. Many issues can be resolved amicably without resorting to termination, if both parties are willing to discuss and negotiate. Financial implications. Be aware of the potential financial implications of terminating the contract. This includes potential losses, legal fees, and reputational risks. Explanation of process flowchart for Clause 16.2 termination by contractor with durations. Starting point. The flowchart begins with the scenario where a contractor faces certain issues or challenges during the execution of a project. These issues might be related to payments, work suspensions, or other contractual obligations. Checking the contract. Before making any decisions, the contractor refers to the contract, specifically Clause 16.2 termination by contractor, which outlines the conditions under which they can legally terminate the contract. Identifying the issue. Payment issues. If the contractor's concern is related to not receiving payments, they would refer to subclause 14.7 payment. This clause specifies that if the contractor hasn't received their due payment within 42 days, they can consider actions like suspending work or even terminating the contract. Suspension issues. If the contractor's work has been suspended for reasons not caused by them, they would look at subclause 8.11 prolonged suspension. This clause mentions that if the work suspension has continued for more than 84 days, the contractor has the right to ask for permission to proceed. If they don't get this permission within a certain time frame, they can treat this prolonged suspension as a reason to make changes to the contract or even terminate it. Financial arrangement issues. If the contractor has doubts about the employer's financial capacity to pay for the project, they would refer to subclause 2.4 employer's financial arrangements. According to this clause, the employer must provide evidence of their financial arrangements within 28 days upon the contractor's request. This is to ensure the contractor that the employer has the necessary funds to pay for the project. Other issues. If the contractor's concerns don't fall into the above categories, they would then refer to other relevant clauses in the contract that might address their specific issue. Taking action. Once the contractor has identified the specific clause that addresses their concern and has waited for the specified duration without a satisfactory resolution, they can then decide on the next steps, which might include further discussions with the employer, suspending their work, or in extreme cases, terminating the contract. Conclusion. The flowchart ends with the contractor either finding a resolution to their concerns or deciding to terminate the contract, based on the conditions outlined in Clause 16.2. Let's delve into some real-world instances and case studies concerning Clause 16.2 termination by contractor from the FIDIC Yellow Book 1999. Case Study 1. Delayed payments and termination. Scenario. A construction company, ABC Builders, was contracted to construct a commercial building in Los Angeles. As per their agreement, the employer was to make periodic payments based on the progress of the work. However, the employer consistently delayed payments beyond the stipulated 42 days as mentioned in Clause 16.2c. Despite multiple notices from ABC Builders, the employer failed to rectify the situation. Application of Clause 16.2. After waiting for an extended period and issuing a notice under Clause 16.1, ABC Builders invoked Clause 16.2 and terminated the contract. They cited the employer's failure to make timely payments as the primary reason for termination. Outcome. The case went to arbitration, where the employer was found in breach of the contract. ABC Builders were compensated for the work done, and the losses incurred due to the premature termination of the contract. Case Study 2. Bankruptcy of the employer. Scenario. Def Constructions was working on a residential project in New York. Midway through the project, the employer filed for bankruptcy and was unable to continue funding the project. Application of Clause 16.2. Def Constructions, after learning about the employer's financial situation, immediately invoked Clause 16.2 grams, which allows the contractor to terminate the contract if the employer becomes bankrupt or insolvent. Outcome: the contract was terminated immediately without the need for a 14-day notice, as specified in the clause for such situations. DEF Constructions was able to mitigate further losses by halting the work promptly. Case Study 3. Non-compliance with financial arrangements. Scenario: Guy Infrastructure was involved in a bridge construction project in Miami. The project was capital-intensive, and Guy Infrastructure required regular financial evidence from the employer to ensure the project's continuity. However, the employer failed to provide evidence of their financial arrangements, as per Clause 2.4. Application of Clause 16.2. Guy Infrastructure, after waiting for the stipulated 28 days and not receiving the required financial evidence, issued a notice under Clause 16.1. When the employer still failed to comply, Guy Infrastructure invoked Clause 16.2a and terminated the contract. Outcome: the employer was taken to court, where they were found in breach of the contract. Guy Infrastructure was compensated for the work done and the potential profits they would have made had the project been completed. Case Study 4. Prolonged suspension of work. Scenario: JKL Developers was renovating a historical site in San Francisco. Due to some unforeseen archaeological findings, the work had to be suspended. The suspension continued for more than the 84 days specified in Clause 8.11. Application of Clause 16.2. JKL Developers, after the prolonged suspension, requested permission to proceed. However, they did not receive any response within the 28 days. Consequently, they invoked Clause 16.2f and terminated the contract. Outcome: the termination was amicable, with both parties agreeing to a settlement outside of court. JKL Developers were compensated for the work done and other incurred costs. These case studies highlight the importance of Clause 16.2 and its various subclauses. It serves as a protective measure for contractors, ensuring they have a way out of the contract if the employer fails to meet their obligations. The clause, when invoked correctly, can save contractors from potential financial and operational pitfalls.
Thank you for tuning in to Growth Mind Company today. If you found value in this video, please give it a thumbs up and share it with someone who might benefit. Remember, growth is a continuous journey, and we're here to support you every step of the way. Until next time, keep nurturing that growth mindset and see you in the next video.